much, Deputy Speaker, and I was delighted to briefly start my remarks earlier, but I rise to speak on the Bail Amendment Bill 2023, and can I start by commending the member for Malvern for his considered amendments this morning and for his detailed remarks on this piece of legislation. I know he has taken considerable time over recent weeks to work through the detail of the legislation and to present these considered and important amendments to the House today and for the consideration of this chamber. And before I address the member for Malvern's amendments, I wanted to touch on the purpose of the bill, which is by and large a very, very sensible piece of justice reform. We've had yesterday another piece of justice legislation before the House looking at tidying up and housekeeping and making some important changes to ensure our justice system is fit for purpose. And this bill seeks to do that by amending the Bail Act 1977 and to change the requisite tests applied in making determinations about an individual's bail. And this includes providing that certain offences are no longer to be Schedule 2 offences, providing that bail is not to be refused in respect of certain offences, providing the two-step tests apply to children in fewer circumstances, making changes to what a bail decision-maker must take into account, including determinations relating to an Aboriginal person or child, repealing the offence of contravening certain conduct conditions whilst on bail, repealing the offence of committing an indictable offence whilst on bail, various changes to updating language used in the Act, and expanding the circumstances in which a court must hear a further application for bail. And, Deputy Speaker, this bill does recognise Acting Speaker now. That was a quick change. Acting Speaker, it's lovely to see you there. This bill does recognise that Victoria's bail laws do require some reform, and I think we've had discussion right around the chamber today to that effect. Since 2013, we've seen a number of bail reforms passed under both the former Liberal government and, of course, the Labor governments over the past 8 years. And these reforms have sought to tighten bail laws and were, in many cases, direct responses to a number of incidents, but of course to the Bourke Street tragedy of 2017, where 6 people were tragically killed. And as a consequence of these reforms over the years, the number of Victorians charged with criminal offences and held on remand has significantly increased. And in some cases, this has been warranted, and it's critical that Victorians are not let down by the criminal justice system, allowing individuals out on bail when they pose an unacceptable risk to our community. But there are also significant numbers of people who are held on remand in this state, and their incarceration comes at a great cost, of course, both personal and financial in terms of taxpayer dollars. And it comes at a significant personal cost to those individuals as well as their families and loved ones who are remanded. And there are situations where Victorians spend more time in remand than the actual sentence handed down for the crime committed. Indeed, the Crime Statistics Agency has stated that in 2018, only 61.7% of women remanded in custody went on to receive a prison sentence, including time served, and that 8.5% of unsentenced women's charges were not proven in court. And this piece of legislation, Acting Speaker, seeks to deal with some of these issues where we've seen the number of people remanded not meeting the requirements of the justice system. And as I said, this significant cost is also one to the Victorian taxpayer when those who end up in remand do not actually pose a material threat to the community. As a general principle, Acting Speaker, it is difficult to argue that people being remanded in circumstances where they do not pose a material danger to the community is justifiable. And so I note that the amendments contained in this bill are a response to the call by the coroner to review the Bail Act following the death of Veronica Nelson while on remand in 2018, having been refused bail. The coroner found that Veronica's death was preventable and could have been avoided with reasonable standards of care and diligence on remand. In particular, the coronial inquest called for a review of this Act with a view to repealing provisions that may have a disproportionate adverse effect on Aboriginal and Torres Strait Islander people. The coronial inquest found that the current Act results in individuals, I quote, presenting no risk to community safety and that they are unlikely to attract a prison sentence routinely result in remand. Acting Speaker, as I said previously, this bill seeks to deal with this issue and largely represents sensible and necessary reform to reduce the number of people held on remand who do not pose a risk to our community. And it's absolutely vital as lawmakers we learn the lessons from Veronica's death, which the coroner has ruled as preventable, and take steps to ensure Aboriginal people are not disproportionately and adversely affected by our bail laws. And that is why the Liberal and Nationals coalition will not be opposing this bill. I do note, however, that I share the member for Malvern's concerns about whether the provisions contained in this bill strike the right balance between people being remanded unnecessarily on the one hand and ensuring community safety on the other. And I know that in my own electorate of Kew, the community is rightly concerned about a range of criminal offences, about a range of crimes: burglaries, aggravated burglaries, car theft. Small businesses regularly raise the fact that they are seeing an increase of theft and petty crime. And we need to ensure that while we're seeing more individuals remanded, we also are hearing the concerns of victims of crime and those who have often been a victim of crime due to a repeat offender. And the statistics do show that a 42% increase year on year of a breach of bail conditions. So if this passed, this bill will make it significantly less likely that people accused of crimes who fall into certain categories will be held on remand. And while this is an important measure, it is essential that some safeguards do remain in place to protect the community from individuals who pose an unacceptable risk to public safety. And that is why the member for Malvern has moved a suite of highly sensible amendments that aim to, first, retain the offence of committing an indictable offence whilst on bail; 2, add 8 serious offences to the list that requires a compelling reasoned bail test for children accused of these offences. And this includes the crimes of rape, rape by compelling sexual penetration of a child under the age of 12, aggravated home invasion, aggravated carjacking, aggravated burglary, armed robbery, and causing serious injury intentionally in the circumstances of gross violence. And as you can see, Acting Speaker, these are all very, very serious crimes, many which involve the use of a weapon when it comes to aggravated home invasion or aggravated carjacking, and seeks to ensure that we're striking that balance between ensuring those people who are not a threat to our community are not remanded, but those who do pose that unacceptable risk to our public safety, the appropriate safeguards are in place. And the third amendment that the member for Malvern has moved is to mandate a statutorily required review of the effect of the amendments after 24 months of operation. And this is to be completed and publicly released within 6 months. Now, this is an important piece of safeguard across the entire piece of legislation, the amendments here today, to ensure that after them being in place for 2 years, we assess their effectiveness, we make sure that they are meeting the expectations of these changes and that we are seeing the outcomes in the justice system that this piece of legislation aims to achieve. And a review of this piece of legislation, of these amendments, and then making sure that that review is made public and that the community is able to understand the outcomes from this piece of legislation will be very, very important to ensure its effectiveness going forward. Acting Speaker, these amendments aim to keep the intention of the bill, which is, of course, to avoid unnecessarily holding individuals on remand, but while ensuring that there are robust safety measures in place to safeguard the community from unacceptable risks posed by some individuals. Acting Speaker, it's imperative that we do strike the right balance between reducing instances of people being held on remand unnecessarily with community safety. It has been the discussion in this place today to ensure that we do strike that balance, that we review the number of reforms that have taken place over the past decade, and that we find a solution to these. And it's for this reason that we will not oppose this bill, but we have put forward, via the member for Malvern, a number of amendments that aim to strike that balance to ensure community safety, and we commend these amendments to the House and urge those opposite to give them due consideration.